and welcome. Thank you. At this time, I would like to open the Personnel Subcommittee meeting of the Commission on Nevada Commission on Ethics. We'll start by roll. Chair Wallen here, Vice Chair Dufferin.
Here.
Commissioner Oscarson.
He's always in front of me. Yes, I'm here, Madam Chair.
That's why. For staff, we have Executive Director Armstrong.
Here.
So she left, that's right. And then we have our Deputy Attorney General in the St. Jules. And then we have our Executive Assistant, Perdoza. Here. Let's do the Pledge of Allegiance now, please. Please. I pledge allegiance to the flag
of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all.
Next item, public comment. Executive Director Armstrong. Has the commission received any public, and are there any members of the public present?
There are no members of the public present, and we have not received any written public comment prior to the meeting, and I'll defer to Executive Assistant Pedroza to see if there's anyone on the Zoom who would like to provide public comment.
We have no members of the public on this.
Okay, good to know. Next item is the interview and consideration of candidates for the Commission Council position. I want to first start with my commissioners, and you all have your questions and determine how many questions we want to ask, and then identify which questions you're going to ask. The interviews are scheduled for an hour and a half total time. I mean, it doesn't have to go an hour and a half. You're probably, oh my goodness. Yeah, that's right, as long as we need. So I'm thinking maybe 6, 7 questions each person. Mr. Oscarson, you good with that?
Yeah, I think so, Madam Chair.
Okay, Commissioner Dufferin?
Yeah, I've got some questions I've identified that I want to ask, and it maybe close to that number.
Okay, let's go ahead and do 6 questions.
Okay.
Okay, and remember, everybody has to ask the same question. Okay, and so I would like to know from you guys what 6 questions you want to ask. Just give me the numbers on your sheets, please.
Okay, you want me to go first, Madam?
Sure.
Sure. I'd like to ask number 2 on my list.
Yeah, it is.
Okay. Number 3.
Okay,
Number 5.
okay,
Number 6. Number 7.
mhm,
And number 8.
Vice Chair Dufferin.
Madam Chair, the questions I'd like to ask are 1, 2, 5, 7, 9, and 10.
My questions here, since we just did that. All right, I think now we're ready to begin here, so thank you for indulging us. Okay. Mr. Perlotta. Right? Perlton, okay. Welcome and thank you for coming out here today. There's going to be 2 sets of interviews if you're selected to go on. The subcommittee will be interviewing you today, and then we will select the applicants who should receive a second interview with the full commission. The commission anticipates conducting interviews and hopefully selecting its commission council at a special meeting probably the week of May 14th, or, yeah, 15th, May 15th.
Yeah,
Our
I think it's
commission
sort of
meeting's on the
late.
17th, yes. So before we start, I would like asking you questions. I'd like you to give us a short introduction and let us know what prompted your interest in this position and why you want to work here.
Thank you, Madam Chair. Yes, so I've been in private practice for 9 years now. And one thing, I went to law school to become a lawyer. I'm interested in actual law, in legal analysis, and that's what I thought I would be doing. However, a lot of what I have done is for the job of a business person, right? And not really interested in that anymore. I mean, I have realized over the years that what I enjoy the most is actual, like I said, legal analysis, legal advocacy, presenting issues, trying to distill issues, trying to find the most satisfactory answers to any legal question that I'm tasked with answering. And so that is what I would like to be doing now, and not worry and consume my time with the business aspect, which is not as important to me. That is, ultimately the motive of any private enterprise. And with government, the motivation is, the fulfillment of the duties of the application or enforcement of the specific legal scheme, statutory scheme that is being dealt with. And in this case, I think the Commission on Ethics has a essential function in society, and I would love to be a part of it. Also, the timing was great because this is the only job I have applied to since basically law school. Well, since I passed the bar and got my first job. And so this is the first one, and I haven't applied to any others because since I started, since I decided that I wanted to take my career in a different direction that is most in accord with what I personally like to do, this is when I started looking at the Nevada State Bar website or the announcements that they provide, and this appeared, and I thought it would be sort of the perfect, the perfect position for me.
Okay. Thank you. All right, now we're going to go ahead and start asking some questions. I will lead off, okay? Questions here. Now, because this is a public meeting and it might not apply to you, the next several questions will relate to your job and what you did before your current job, before you became in private practice. And if you want, you can talk about your current job. And how would you change things at your current job, your practice? How would you improve your practice?
Sure. Well, so as you know, I am, a solo practitioner. So throughout the years, any changes I've deemed necessary or desirable to change, or to make, I have made. At this point, I would say, there have been some technological developments. You're probably familiar with ChatGPT and other artificial intelligence applications that help a lot with tasks that are repetitive, that, for example, we have to send requests for documents and things like that all the time for medical records, things like that. That could be automated. And this is very new. And I have already been stepping away from my practice. I stopped taking new clients January of last year, and I referred them to another law firm that I work closely with. So mostly what I've been doing for the past, year and a couple months has been finishing out some cases that I just kept. And I have like 2 left, I believe, that have very little that's needed for completion. And those I'm planning to transfer to one of the law firms that I work closely with in the event that I wasn't able to continue my private practice. But the reason I haven't made any changes, that's because this technology is very new, and my mind has it, I wasn't planning to continue developing my practice, but that would be something I would do. I'm sure there's other things that I would like to do, but I think that would be the main one, just because it would make things a lot more efficient.
Um, In your career, can you tell me about a failure that you've had
Sure, I mean.
and how you handled it and learned from it?
Well, yeah, I have always been terrified of failing, just because, not because it's, a failure would just remain a personal failure, but because it would affect clients. It's my job entails representing other people, and I don't want to, I feel that my duty towards them is sacred, and that would be, to me, the most difficult thing. So I've taken great pains to not make mistakes, to the extent that I have been able to. If anything, I would say times that I've realized that I could have prepared more, that there was something that I didn't think of previously, that I didn't anticipate, truthfully. And so what I learned from that is, well, now I have to anticipate that, now I have to think about that. That's one of the considerations going forward that I just have to be mindful of. So I would say, luckily, nothing has actually constituted a failure, at least that I would, or that it would be considered, legally a failure or anything like that. But for me personally, I did feel, in a couple occasions that I could have done something more than I did. And so the lesson was, do it in the future. And then now you avoid that feeling that maybe I didn't live up to my own personal standards.
Okay. Can you tell me about, have you ever done something for someone and didn't expect anything in return? Give me an example.
Okay, so in my practice, many times I had clients of mine or people that did not become clients because their issue wasn't within the purview of my practice. But I felt bad, about it and about the situation and try to help them. So, and a lot of the time, the reason was because I knew other attorneys wouldn't take the case, or because the individual didn't have money to pay an attorney that would take the case. So countless instances. At the beginning of my practice, I was doing some family law, some immigration law, and so throughout, I continued helping people who had issues in those practice areas, because normally people don't have the financial means to hire an attorney what they charge. So I provide guidance, took it upon myself to, write letters or draft documents for them, things like that, or just represent a component. So I don't know a particular instance, but because there were many, like I said, it's something that I actually had to at one point start limiting a little bit, because it was taking, I had to be profitable and it was taking a lot of time. So one of my learning or one of my lessons was to know what I could take on and what I couldn't. But within within my abilities and means, I always try to help.
If I were to ask 3 friends to tell me something about you, what would they say?
They would say I am honest, I'm sincere. I've always felt that whatever I have come to believe or to think about something, if I do think it's the right thing, then I shouldn't be ever ashamed to be truthful about it. And I think that everything in life, it should be like that. So I would say honest, sincerity, kindness. To me, is very important to be kind. That should be just the default always. And even when there's an adversarial situation or something, kindness never harms the ultimate result, right? Because I'll do what I have to do, but I can be kind while doing it. And lastly, I don't know if I'd say funny, but I like humor, so I enjoy when others make me laugh. I like making people laugh. And so I would say those 3 things.
Well, we have a comedian in this group, so.
Oh,
Yeah.
who is that?
Commissioner Oscarson
Ah.
and Vice Chair Duffrin. So.
He's much better at it than I
Yeah.
am.
we
He's
get
just so humble and kind.
Well, I'm glad that the humor is valued.
it definitely is.
Get you through the day.
Would you characterize yourself as someone who gets ahead of deadlines or someone who your work is driven by deadlines?
Well, I will say my default probably would have been to work with deadlines through school and everything. I mean, that is what really pushed me to get things done more than anything. But throughout the years, I've found it's just much better for my mental peace to just get things done as soon as possible and not have to have a looming deadline, because it's always the pressure of a deadline has always made me meet it, but when it's getting closer, it's a lot more pressure that I care to have. So now I would say I definitely try to stay ahead of them.
Okay. And then my final question is, do you prefer working collaboratively or independently?
Collaboratively, definitely. I would say for anything that I have, that is my own responsibility, then I like to be able to do my part. But after that, I love to get input from others. I love to consider their perspectives also. And as a whole, definitely collaborative.
Okay.
I found that's always the better way.
Okay. That completes my questions. So Vice Chair Duffrin, please.
Thank you, Madam Chair. I guess it's good afternoon, Mr. Peralta. Thank you for applying for this position. I appreciate it. And I've got just a few questions here for you. Sounds like you saw our opening on the State Bar's website, which happens to be where we're at today, which is kind of ironic. But when you decided to apply for the position, did you get an opportunity to look at our website and look at our mission and guiding principles, and even our actual statute, the NRS 281A? Did you get a chance to look at those items, and did you and if so, in what ways do you believe you could assist the commission in ensuring its objectivity, independence, and impartiality are beyond reproach?
Thank you for the opportunity, first of all, Commissioner. I appreciate it. Yes, I definitely looked at I got excited when I saw the position and when I sent in the application, or before and after. Like I said, because it's a position that really meets all my the criteria of what I would like to be doing with my career going forward. So I reviewed the chapter 281A. Read all of it. Hopefully I'm not getting quizzed because I don't know how well I memorized it, but I did go through it. I understand what the purpose is and generally all of the aspects of this legislation scheme. I reviewed some of the opinions that have been that are there, just to have an idea, since I know that is one of the roles of the council is to draft or assist with these opinions. So I read a few, of course, the mission statement. So I believe I'm well acquainted with the mission, the purpose of the commission, and with I think the job that I would be doing if I had the honor of being selected. Oh, and to answer the rest of the question, how I could help is, I think by being very scrupulous in analyzing in every part of the statute, any judicial opinions pertain, that relate to this legislative scheme. I didn't actually review that, but and review all everything, every opinion that has been issued, things like that. So have a complete mastery over the whole scheme over which you have authority, duty of enforcing and managing, and give my best effort every time to answer any any requests for advice or opinions or any complaints, and to provide my advice to the commission and the answer to any questions that the commission asks me with answering. In any of their opinions, doing that to the best of my ability, taking that very seriously.
Great, thank you. Do you have any experience in preparing or presenting meeting materials for approval at a public meeting? And if so, can you talk about that?
I do not have experience, but I am a quick learner and dedicated one, so I would definitely make an effort to become knowledgeable right away.
Okay. Have you ever provided legal advice to an agency or private business on their litigation matters and or daily operations?
Yes, on litigation matters, I have provided advice to private entities. By and far, I represented private individuals, but there were a few instances of representing business entities.
Can you kind of tell us about that?
Sure, nothing too exciting. I did in business matters, contracts and things like that, and also litigation when they were, so one I can remember was a client who did not have workers' compensation insurance, and I had to represent him through that. There were, like I said, not many because these were sort of outside of my main practice area, but I reviewed all the applicable laws. I provided my best counsel to them and did what was within the scope of representation.
Okay. Well, what steps do you take before making a decision on how to solve a problem, and why do you take those steps?
Okay, so I would say number one is to understand what the problem is, the question, to set, especially if there's multiple aspects to the question, separate each individual, try to understand what is really the problem, because sometimes, questions can be a little convoluted, so really clarify that. Once I have the questions, then look at all the possible sources for solutions, applicable sources, right? So if it is a legal question, look at any statutes that apply, any case law, and of course, talk to the person who wants an answer, right? So normally a client, and understand what their concerns are, why they have the question, why the question arose in the first place, and things like that. And then review everything until I am sure that my answer is the right answer, and that there's nothing else that contradicts that. Or if there is something that contradicts that, just understand on the basis of the contradiction, try to resolve the contradiction, or just present it, the contradiction to the person who wants the answer. So I think those would be the steps. But definitely, one thing I always need to do, even when I feel like I found the answers, I always need to make sure there's nothing that contradicts it, or that is the challenges it a little bit, just to make sure I anticipate, even if it's not something that would change the outcome, but that I could address it, if someone presented it.
Have you ever argued before a district court or Nevada Supreme Court on an appellate matter?
Yes, so specifically appellate matters?
Or anything related to
So
that?
district court, yes, a lot, because any motion would require a hearing. So countless times through litigation. And then for appellate matters, there were two cases of mine that upon a final determination by the district court, I did not agree with. And so I just appealed to the Supreme Court. Arguments were not requested by the court, so I did not have the opportunity to make the argument orally, but they made the decision on the pleadings, the opening brief, and reply. And first one was unsuccessful, but I think the challenge was something that I still believe it was correct, but I think it just would go against sort of standard practice, for a long time. So I think, and the margin, there was some margin to interpret it the way it was interpreted. That was my first one. And the second one was successful. So that was very satisfying after. I was accused by the opposing counsel, or I was threatened with a rule-led motion for sanctions, saying that what I was doing was wrong, and I should basically be sanctioned by the court for doing it. And it was a partner at a prestigious law firm versus just me. So I was, of course, worried, but like I said, I reviewed everything, make sure it was right, and once that was my decision, I said, well, I have to go forward because I don't agree with the threats being made are, and the basis for them. So I said it was successful, so I have to, and it was just by myself, and I had never done anything like that before, just because it had not arisen in my practice.
So, I'm assuming those are all public cases.
Yes, sir.
So could you kind of tell us more about either one of those cases, your experience with that and like the actual outcome?
Okay, well,
You did say one was unsuccessful and one was successful, but just kind of tell us more like what kind of cases were they, and just so we have an understanding about what kind of law you practiced for those courts.
Absolutely. I don't want to bore you too much. Please
No,
go
no.
on.
That's okay.
No,
You-
there's
you need
nothing
that-
that you're gonna tell us that's gonna
Okay.
bore me.
Okay, so the first one, there is the sort of like the longstanding law is that the conclusions of a police officer when there's a car accident are not admissible as evidence. And the whole rationale is that you don't want the jury to be unduly influenced by what someone who is seen as, as an authority said about it, right? So what's looked at is just the actual evidence, facts, basically, say the facts upon which the officer made a decision, that's what's presented, right? And I think this is great, right? I agree with the law, except in this case, the police was the tortfeasor. And what happened was, there was a marathon, and I don't remember, it was 2017 or something like that. And the police were directing traffic. So my client had a green light. And the officers that were directing traffic told it was a cab driver coming in, perpendicular direction to go through a red light. But they didn't tell my client to stop. At least this is, I wasn't there and there's no video, but that is how I understood what happened, right? And so then nobody was cited for the accident. I think the officers understood that an error was made, that the coordination or communication between them failed, and so they allowed two cars to enter the intersection, and car with a red light, without telling the one on the green light to stop. Let me, like I said, I just don't want to talk too much about details that might not be relevant, but anyway, so the reason, so I wanted to admit the police report into evidence because the officers did not say that my client, and that's to me a big, what was persuasive about it is, if someone disobeyed a police officer telling them to stop and caused an accident, I don't think the officers would be too kind in their report, or they would at least issue this person a citation, something. It would say this person disobeyed, but it didn't say anything like that. It just said, well, there was accident and this happened, and that was about no fault. We cannot determine fault. And to me, my whole argument was, how can you not determine fault if you're saying that you were directing traffic and that you're doing it properly, and someone disobeyed you? How do you just let that slide? That was my argument at trial, but the other side said no. Police reports cannot be admissible because the law or the rule that I told you about previously, how they're not generally admissible, it's just something everyone, just take into their mind. They don't look at the nuance. It's just police reports are not admissible, right? It's really just the conclusion of the police officer, but police reports are not admissible. And I wanted to introduce it to prove, well, why are you saying that he was at fault now, 2 years later, but you didn't say that on the day of, right? And that's, I wanted to show that. And the judge agreed with the other side and said, no, we're keeping it out. Police reports are not admissible. So the jury did not get to hear, to me, what was the most persuasive aspect of this, right? Without that, it's just, well, there was an accident, and these people are saying the police made a mistake, and the police are saying they didn't make a mistake, and that's it. And we could not even refer to the fact that at the time, I wanted to at least make, a question the officer that at the time, you didn't think that he was at fault, right? But I wasn't able to ask that. So we lost the case. And it was I'm gonna say the only case that I lost. And I thought, well, look, if I lose, I put in my best effort. That's, what can you do, right? As long as I know I put in my best conscientiously, then obviously I would still be disappointed for the client, etc. But in this case, I told the client, look, I think that was a mistake by the judge. I think this could be challenged because I think there is a distinction here in how this was applied, right? I don't think we were not saying we want to establish what the officer said as a fact. We don't want to say, hey, usually the officers would say this person was at fault, because it's not the police who was involved. And so, you want to bring that to court to say, well, the officer said that person was at fault, and sort of skipped through having to prove the case. But in this case, it was different. It was to show their state of mind really at the time. So that was my argument, in brief. And at the end of the day, it was an unpublished opinion, and it said, after of course years of work and everything, no, this is, and you couldn't prove or something that this would have changed the outcome, which I don't know how anyone would do that, right? I can't sort of provide a alternate universe in which this did happen. Anyway, so that was the first one. The second one, if you want to hear
Sure.
it. Yeah.
No, please, I don't want to.
Okay, the second one is a happier one because the outcome was successful. Well, kind of, I'll tell you about the story about this. So this one, my client was severely beaten at a night, at a bar, club, and we sued the property owner, the business, and he had internal brain bleeding. His jaw was broken. It was bad. Right now, he has had to live now with the consequences of this attack ever since. So, we filed a lawsuit, and they didn't answer. One of them, I was contacted by a lawyer who was, they said they might be retained by one of the entities. Anyway, at the end of the day, they didn't respond. So I saw a default judgment. We had a proof of hearing, and the judge awarded $1.7 million in damages. When we started, I didn't know how to collect money. So I never, usually with personal injury, once you get a judgment, no one takes something, to, let's say, the final adjudication if they haven't identified either insurance or a source of recovery. But in my mind, well, I at least have to do that for the client. And also these entities, I don't know whether they have insurance or not. It is worth pursuing this. So took it, to that point without knowing if there would be any source of recovery. And again, we don't learn that. And personally, we never learn how to actually collect that. Usually if it gets to that point, if for some reason there's no source identified by the time you have done all that, it is referred to an attorney that does collections. And so there's some attorneys that just dedicate themselves only to collecting judgments and things like that. So that's what I did because I had no clue. I didn't know how to go after them. And this attorney found a Wells Fargo account somehow. Again, I don't know the details, and garnished some of it. And it was only like $5,000 out of, again, a $1.7 million judgment. And at that time, then this prestigious law firm stepped in and said, whoa, what are you doing? This is my client was not liable for this for these reasons. And so you have to announce at the time that I was threatened with this motion for sanctions. However, the statute on judgments and when they can be set aside, it says very clearly when it has been 6 months, like after 6 months, the court no longer has jurisdiction to consider a motion to set aside the judgment, right? And so the other side, like I said, when they came in, they said, we're gonna file this motion to set aside the judgment, but we're gonna give you an opportunity to just voluntarily or to stipulate, to set it aside. Otherwise, hellfire is gonna rain on you, right? And like I said, I mean, there's a law firm that has hundreds of attorneys across several states, and then just me. And so I was like, oh God, I need to make sure that everything I'm doing is there's no issue with it because they will find it. And, so I reviewed all the applicable law, I reviewed everything, and I said, no, I'm not doing that. And so they filed a motion, and I made the argument before the judge that the court no longer has jurisdiction. It's been 15 months at the time, it's been 15 months since this was issued. And after 6 months, there is no jurisdiction. So, I mean, it's actually very clearly, there's some situations in which, there can be an exception to this, right? But it didn't meet any of them, right? In the main case, however, the judge decided to set it aside. And so, it was disappointing because it's like, oh God, okay, so the only recourse is to file the appeal. And I didn't have success the first time, so it's like, who knows if this is going to work. But to me, in my own estimation, which like I said, very careful, very thorough, this should be the outcome. So I was like, okay, I'm gonna go for it. And did it. And it took forever, right? Like all these steps, collection, because the collection itself took a while, then them trying to do the motions, the whole process took a while. So I finally got the decision July of last year. And it was right after my sister's wedding. We're in Costa Rica, we're originally from. And so it was great because we were at the beach, at a restaurant, and a friend of mine said, hey, congrats on the decision. And I hadn't heard anything about it. So I said, what? And and so then after that I found out. So it was very happy. Of course, they filed bankruptcy afterwards.
Of course.
So I mean, we pursued that whole part of it. But anyway, that was that experience. My sister, who was in law school at the time, she through her law school, she was able to get credit working at a law firm. And so we asked if she could work in my law firm, and they said yes and everything. And so she was able to participate in that. So it's pretty great. She graduated, and I was waiting for the bar results coming up, I think first week of May. So anyway, that was sort of really nice that we were able to.
Thanks for expounding on that. I appreciate that. My last question is, based on your understanding of this position, what is more important? The ability to work as an independent contributor or as a team member?
Well, I would say as a team member, since ultimately, the jurisdiction and the authority is on the commission. So I see my role as auxiliary to the commission. So I would, of course, and I know there's an associate counsel, there's a legal researcher, and there's other members of staff. So like I said previously, the best approach is collaborative to get results where everyone gets to contribute and where their contributions are maximized.
Great, thank you very much.
Commissioner Oscarson.
Thank you, Madam Chair. Mr. Peralta, thank you for being here. I have some questions. I don't think they'll be having heard you answer the other questions, I think they should be fairly, fairly simple for you. Appreciate your passion. I think it shows through. First question is, what have you done in the past to prevent a situation from becoming too stressful for you or your colleagues to handle?
Thank you, Mr. Commissioner. I think I have learned from situations where the stress and the pressure was, I guess, hard to endure. But of course, when there was no way, I would never abandon something because it got too much. If I committed to it, I will see it through. But of course, then the next time I'll make the same commitment. So I think understanding why a situation can become that stressful, and so that I can now in the future know what to do so that it's not. So I think to answer the question is just learn from experience. And wanting, I don't like stressful situations. And so I make an effort to prevent that from happening.
Okay. Have you ever held a position where you could not ask for guidance from other persons in your workplace, and how did you handle this challenge? I would assume working independently in your own law firm, there's not a whole lot of other people unless it's colleagues from other entities or organizations that you could speak with. So have you ever felt like you couldn't ask for guidance from those people at other workplaces? Or do you have the relationship that exists that you can do that?
I felt like I did, but at the same time, when they don't have a stake in it, when other people, I mean, they will help, they will provide feedback, but at the end of the day, when it's on you, whatever decision, I will say that situation did arise when I just, even though you might think you have the right answer, I mean, there's always that possibility that you're missing something. So I think for me, that's been one of the hardest things to not have someone, to not have others that were, let's say, like equally qualified, right? Because I was by myself. Luckily, I did have many friends in different practice areas that, I would ask for advice and things like that. But a lot of times I did feel, sometimes they just were not acquainted with the issue very well. So their advice wasn't that helpful, right? I mean, I'll try to present the issue, but I don't want to, I don't like bothering people too much with a lot, right? If it's advice that won't take a lot of time and effort for them to provide, then fine, but I don't want to say, okay, look, here's my entire case, here's the issues. So I would say that was difficult, and there were times that I felt that that it wasn't an option in the same way as when you're part of an institution that has other people. I'm more comfortable in that situation in general. For example, I know that there's, I guess, two attorneys, aside from the council as part of the staff of the commission, that of course would be able to provide their own, things. Even if it's not their job, they might say, no, I don't think this is right or something along those lines. So I think, I understand that the council position might have instances in which it comes down to, like, this is your decision. You can't have someone else decide for you. And like I said, I have had to do that many times. So I think now I am comfortable when that is the situation. Say it's unavoidable that I have to make the ultimate decision without much team's input.
Yeah. Can I do a follow-up on that? Can you give us an example of how you worked through that, So I'm curious.
I think so. Try to understand what was, like I said, again, my specific question, right? Because again, with anything, there's always different aspects. So what is it that what is the one that's bothering me, right? So that when I ask somebody, I can keep it simple, try to keep it as simple as possible. So that was step one. Okay, so this is what I'm not sure about. This, let's say I'm sure about, so I don't need to ask for it. I just know. And then identify who would be able to help me with that. And then reach out to them and say, look, I have this issue. This is what this is my, let's say, like preliminary answer to that. I would like to know if you have any thoughts about it, if you agree or disagree, particularly with this. I want to see if there's any disagreement. If anything is, as I was mentioning earlier, to me, if I have an answer, I'd like to know what the disagreements or the challenges are. So I could really think about them and see if there's some merit there, or if I have a good response to those challenges.
So at one point you said, and then there's sometimes where I can't ask anyone and I have to deal with it. How did you deal with it?
I did my best to make sure that was the right answer. What I arrived to ultimately was the best answer that, like I said, just in good conscience, after giving it my best, that was, and that I would be able to defend it, right? To say that this is why this was the answer I arrived at, and I understand there might be differences, but I have to at this point defend it, right? Or advocate for this answer. So I think that's.
Okay, thank you.
And accept responsibility, sounds like you.
Of course, because at that time, that's all that,
I think that's the key. Okay. Thank you for the follow-up, Madam Chair. What if I, as a commissioner, had a question? How would you handle responding to an individual question from a commissioner? And do you think that legal counsel should provide the other commissioners with the same information? So let me read it to you again, just so I can clarify it, because it's a lot. I probably wouldn't have picked that if I would have not realized it was so many words. It's hard for me to say that many words at one time. Let me get a drink. Let me have a drink. Okay. What if I, as a commissioner, had a question? How would you handle responding to an individual question from a commissioner? Do you think that legal counsel should provide the other commissioners with the same information? So you can roll that in together if you'd like.
okay.
That's certainly what I would do, but it's up to you, Counselor, however you want to do it.
Okay, so I'll say, I'll do a couple of things before it gets to that point, right? Before I'm in a capacity to do that, I would like to meet one-on-one with other members of the staff. I understand that the associate counsel has been in her position for some time. I actually read some minutes of previous meetings, just to see a little bit of the history of this opening. And I know she did, the counsel who retired did an excellent job according to the minutes and what everyone expressed. If possible, I would like to meet with her and learn a little bit about the position, how to be good at that position, how to provide a good service to the commission. Meet with everyone else for the same purpose. Again, review the statutes more thoroughly and everything, so I understand what I can, because I remember reading something that pertains to this, and I don't, so I don't remember exactly if you could, as a council, let's say, have private conversations with anyone, the commissioner, or if the information has to be shared with everyone. So I think I would limit myself to the law says about that, right? Assuming that, I guess, and without knowing the specifics, but that would be what I would go by, is what am I allowed to do, and to do that.
So you'd find your boundaries. You'd find what your limits were. And Ross, correct me if I'm wrong, but isn't it, Liz represents you and council represents the board, correct?
That's, yeah, primarily, at least in the complaint case context. Yeah.
Did I say that right?
Yeah, because what happens in our complaint cases is we work as an office team together until a specific point when it becomes an actual contested matter, and then at that point, the individuals who can still participate, the commissioners, you represent them in that matter and help them figure out what to do. And kind of so that wall goes up between our team and you and the commissioners. And then our senior legal researcher kind of helps you during that phase of the process.
So, yeah, I would like to understand all of those, all of those dynamics so that I am clearly above board with anything. That said, of course, I mean, I would always be willing, like, within my authority to provide counsel to when needs it. Always be very available and useful. Obviously, that's the position entails.
Okay. Good. Thank you, Ross. Let's see, you're almost halfway through. What? Trying to give the guy a break, man. He had a drink glass of water. Do you want something to drink? Would you like
No,
a
thank you. Appreciate it.
coffee, tea? Let's see. How would you handle two commissioners disagreeing on the position the commission should take on a matter? Read it again.
No, I heard you. Thank you. Well, again, I think once again, I want to have clarity of all these types of situations before they arise, right? Of all the potential situations like that, so that I handle it correctly. That being said, I mean, if my job is to provide, legal counsel, I mean, I think irrespective of what each one is saying, I would, my own independent opinion, and of course, having considered what they said, but my own independent opinion is what I would present and set forth. So even if that would favor, I guess, one of the or the other, but it wouldn't be based on this individual commissioner. What they're saying, again, just based on my understanding of what the role is. And so if my role is to say, well, this is my advice, right?
Right.
And you to decide. If I have to be, like the breaking, which I don't think that's that would be the situation, then I mean I would support the one I believe is the correct one, but
Well, I think the beauty of this commission is there's some very bright, articulate attorneys on the commission.
right.
I sat next to one today, and classic example today is where we talked about a case. We talked about what what we thought was appropriate. I didn't agree with what council came up with. So I disagreed and voted nay. That doesn't make us any less any less cohesive as a group or any of those kind of things. It just says, I personally thought that there was something different. And when you seek out information from staff and how they can, to the degree that they can provide things, gotta make sure you're not collaborating, you gotta make sure you're not talking about things in groups, those kinds of things. It's important. So those are good answers. I like the fact that you say you want to know what your boundaries are and what your limits are. That's good. Let's see here. All right, now you're almost 2/3 of the way through. What is your protocol for customer service, including returning phone calls and emails?
As soon as possible, as soon as practical. Again, from my experience with having customer clients, for so many years, I've found that the thing that matters to them the most, oftentimes, is not the results, but it is the constant communication, knowing at least responsiveness, I would say. If they have, also because of their own peace of mind, right? So they have something that is bothering them, that is maybe stressing them out, and they want me to just say, oh, don't worry about it. Or, sometimes, for example, there would be an issue that would arise. And so, say happen, right? They call me and there's the issue, and they would call me later today and then tomorrow. But in my mind, I'm like working on solving the issue, right? So it's like, I want to solve that, so tell my case manager, the person who would usually answer the calls, tell them I will get back to them. Until in my mind, once I had the, because sometimes I wouldn't know exactly what would be, you know, the outcome. I could tell them, well, look, this is what happened, this is. But in my mind, I was very results oriented, so I wanted to have the results and say, okay. But I found they prefer for me to just say, okay, I'm working on it. And then me calling them, you know, 2 days later, or something, saying, okay, it's solved, right? So I learned from that a lot. You know, in my mind, I prefer to just, you know, I will trust that whoever is tasked with solving the problem for me is solving it. But a lot of people want the reassurance, want to know what's happening, that they're being, you know, heard, or that their concerns are being addressed. So to answer the question again, to reiterate my answer is immediately with all types of communications. I mean, immediately to the extent, of course.
24 hours,
Exactly.
6 hours,
Exactly.
45 minutes.
Yeah, so if I'm not, you know, if someone was reaching out to me right now, and I'm here, I can't respond to them. But so that was as soon as possible, as soon as practicable, but definitely within, you know, within the same day, unless there's some, you know.
What's your policy, Ross?
See, as soon as possible. I was just thinking about it, and like in this particular position, it's interesting because I know that like when you ask that question, you're probably thinking about the role of commissioner, but where that customer service comes up a lot is the drafting of advisory opinions, where you have nervous folks out there about they need an opinion on a vote they're going to take in a couple weeks. How do I do it? And I think you're right. Sometimes you want to be able to, oh, just provide the exact same answer, but they mostly want to hear like, oh no, I know that you're out there, you're not left alone. So
And I know sometimes we cover up, you know, with stuff that we need to do because it's, I mean, being a new kind of temporary role for you, it's probably hard because there's some, you know, there's some urgency to some of these, especially the advisory opinions that people do. So it's a challenge sometimes to get those done, and they do get anxious because sometimes it affects, in most times it affects their livelihood, what they do. Can I do this even though I'm not doing this anymore? Is a cooling off period. Is all those kind of things have taken place to do those kind of things. So, okay. I don't want to disappoint you, but this is your last question.
Oh, man.
Quite honestly, for the record, he's much funnier than I am. This is a real interesting one, considering that you work private practice. The position of commission counsel is a salaried position versus an hourly job. Do you understand that the legislative session, and I know you were there because we talked about that earlier, is 120 days of dedicated time, often including weekends, nights, holidays, whatever other time, birthdays, anniversaries, Christmas, no, not Christmas, but, you know, I mean, those kinds of things. And you're kind of at the, you're not kind of, you just are at the will of the legislature as to whether they want to have meetings, the closing budgets towards the end of the year, all those kind of things take, end of the session take significant amounts of time. We're having a conversation earlier with Ross. Got some things that we're watching, and Ross is going to basically borrow my motorhome and live at the legislature. So he can, and put little microphones everywhere so he can, not really, so he can pay attention to everything that's going on. Now, he's done that before in his previous role. For somebody who, I know you have some legislative experience, you know how crazy it gets. So will you commit the time needed to assist the commission throughout the legislative session and beyond?
Yes, sir, and I think to address the first part of the question, I think, you know, my, I guess, position for the last few years has been akin, if not even more, have more of a responsibility to be available and doing what needs to be done at any time. Because if an opposing party files a motion, I have to respond timely to it. If anything arises, no matter what my plans were, I have to, or serves, you know, discovery requests or anything that happens. I mean, that would happen all the time where something just comes up unexpectedly, and now I have to deal with it. So that wouldn't change too much. And I'm saying, so from your question, I guess I have a question, if that's all right.
No.
Okay, I'll say. So is the legislative session also a busier period for the commission than the rest of the?
Go ahead, Ross, you can answer that.
Yeah. Yes, because it's the legislative session. It is not, and maybe I think the way you might have been asking about, like, do we get a lot of extra complaints because the session is going on? No.
Okay.
But we have to go defend our budget and analyze the different laws that are being proposed and,
And I would say yes, because you'll be out a lot.
yeah, that would be the
And so,
trick,
yeah,
yeah, because I'll be in the building, as they say, and then there's some of those other tasks like the drafting advisory opinions or review of documents going out that would then fall to the council to assist with.
Yeah, that's out of curiosity, but yeah, I mean, whenever the busy times are or not, I mean, I understand what the position requires me to be there, to be able to do that job.
just don't want to paint a fairy tale for you of what it entails. And I think that the fact that we heard some statistics today that are all public record, but last year we had how many advisory opinions for the whole year?
Oh, last year we were at about 54, I think.
Right, and already this first 4 months,
21.
we're already at 21. So that's a lot. I think a lot of that's due to Ross's outreach on social media and those kind of things, making sure that people know that they can ask for those opinions. Because my philosophy has always been with this commission is that you don't want to find people. You don't want to do things that aren't necessary. You want to work together with them, but that process starts with an education. And that's what Ross is just outstanding at, educating people. And you trained how many, 147 people already this year, something to that effect?
Oh, for the fiscal year, we're at 1,300.
Oh, 1,300, okay. I forgot the other one.
Okay,
That,
that concludes your questioning.
I may have a follow-up.
No?
Okay.
Thank you. All right. So if you're appointing our commission council, you're going to be required to file a financial declaration with the Nevada Secretary of State that discloses certain details of your private financial information. And do you have any concerns with the filing?
I didn't know about it, so it would be public.
Yeah, for public reference.
Well, I mean, no, I wouldn't have an issue with it.
And have you read the restrictions on the position of commission counsel listed in NRS 281A.250?
Yes, my understanding is no other employees.
That's correct. And there's 3 main restrictions, and I want to confirm that you would abide by the following if you're hired. Commission counsel is precluded from being actively involved in the work of any political party or political campaign. Will you comply with this restriction? Okay. Commission counsel must devote their entire time and attention to the business of the commission and not pursue any other business or occupation or hold any other office detracting from the performance of these duties.
Yes.
And then, except on behalf of the commission counsel may not communicate directly or indirectly with the state legislator or member of a local legislative body on behalf of any person to influence action on certain legislative or policy matters. You comply with that?
Yes.
Okay. Do you have any questions for us?
I don't believe so. I think you have provided a lot of information about it, and I learned some just researching the commissions as well.
Okay.
So just thank you all for your time very much.
Okay, is there anything else you would like to add to help us in our decision?
Not only that, I would be most honored and enthusiastic to be able to perform this job and to work with all.
Do you have a sample of a document on which you were the principal drafter?
Yes.
Okay, if so, can you please provide it to our Deputy Attorney General, Lena St. James?
I'll give you a
St.
copy.
Jules,
I'll give
so
you
it
a
can be provided to the commission if you are selected for another interview.
Of course.
Okay, and then the next steps, like I said, we will be making a decision today, all right, after our final interview, to see if we're gonna send anyone forward before the full commission. And then we'll have a special meeting like the week of the 15th of May. And if you are selected to go before the full commission, besides answering questions from all the commissioners, you will be asked to make a presentation on an advisory opinion and a jurisdictional recommendation. And so if you are selected, then we will be sending, you're going to be sending out the draft thing. Because I think, oh, you're going to send it?
Yeah,
Okay, all right. So if you're selected, then we'll be sending it out to you so you can get started working on it as well. So with that, that concludes our interview. And thank you so much, Mr. Pearl, for coming in and seeing us today. We really appreciate your time
Yeah,
and
thank you all.
consideration.
Thank you.
Thank you
All right.
very much.
Thank
Appreciate
you.
it.
All right. Have a good rest of your day.
You too.
We need those things.
So, good afternoon, Mr. Matsuka. Is that correct?
Matuska, can you hear me?
Matuska. Yes, we can hear you.
Michael Matuska, good afternoon.
Thank you. Welcome, and I have to tell you that the way this room is set up, with me looking this way, you see my face, but I can't see you. So please bear with us as we look at you with the side of our head. But I'm going to introduce my fellow subcommittee commissioners so you can see their face. They're going to look at the camera. So the first one is Vice Chair Duffrin. And then
Hello.
we have Commissioner Oscarson.
Do I look okay?
You do, you look very good.
My time?
You all are far away from the camera and I'm a little closer to it.
Yeah, I know. This room's a weird
It's
looking room.
kind of a weird shaped room, so.
Anyway,
Okay.
well, welcome.
Can you hear us okay?
Yes.
That's the important thing. Because
Can you hear me okay?
Yes, we
Yeah, I
can.
wish I had one of those, but I don't. So.
Yes, we can. So, all right, we're going to go ahead and get started. Welcome. And I just want to kind of go over some procedural things about how the process is going to go. There's going to be 2 sets of interviews. The subcommittee will be interviewing you today, and then we will select the applicants who should receive a second interview with the full commission. And the commission anticipates conducting interviews and hopefully selecting its commission council at a special meeting the week of May 15th. Okay. And that would be if you're considered to go forward. And before we start with the questions, I would just like to have you give us a short introduction and let us know what prompted your interest in the position, the commission council position, and why do you want to come work for us?
Well, good afternoon. My introduction is I've been practicing law in Nevada since 1995, always in private practice. First worked for attorney Daniel Walsh in Carson City. He was, I guess what you'd say he was close to retirement, but finishing up some very large cases, including the seminal, the TRPA case regarding IPES in 1994. Went to work for the Brookshaw firm in 1998, started as a partner there, I believe in 2006, and left the partnership in 2011 to set up my solo practice. And my practice has largely continued from what it was previously. It really is a varied civil practice, variety of business clients, transactional matters, homeowners associations, construction clients, a number of appearances before the administrative boards and licensing boards in Nevada. At the Brookshaw's firm, we represented a number of GIDs and water districts. I've also had an active litigation practice. Just by circumstance and partly by design, the litigation practice has been changing to more of a transaction-based practice. When I had the large litigation cases going, it really would not have been possible to leave those and take a different position. I think the timing is good here. My 2 largest cases came to an end, one on December 23rd and one, I'm forgetting the date, but in 2023. So actually, there is an opportunity for me now to transition out to a different career path. I've been hoping to do that for some time, but it has not been possible just with the caseload. So this is good timing. I'm interested in the subject matter of ethics. And quite frankly, it's a field that I think that I would be good at. I've gone back through some of the minutes, and I can see that your prior counsel, Tracy Chase, it looks like she left her position at the end of 2022. And I could see the commendations that were put in the minutes in December of 2022, and comments that those are large shoes to fill. And I do appreciate that. I can tell you a little bit about my philosophy, how I approach the legal work. I think there are three keys really, and it starts with the organization of the office and the preparation and anticipation. I think those are really the three keys. And going back through the minutes, I can see that there's been an emphasis on organization in this office, and I don't know if that really comes from this board per se, or from the executive director, or if it just is a matter that procedures have been honed over time. But I can tell that this board has its procedures in place. One of the things I was looking for, of course, is to make sure that there was a report on current cases, a case log, and there is. Even in my small office, I have to keep a case log to make sure that we are keeping up on things and keeping up on the deadlines. As far as the preparation, I am very satisfied to say that my work stands up and gets excellent results because of the preparation that goes into it. I've cited some of my reported cases, some of the cases that have been cited by the Nevada Supreme Court. And you could, of course, go to those cases to see what the work product is like. I was taught long ago by Dan Walsh, the first attorney that I worked for, that cases are one in the library. And I still do that. And I still research my own cases. And I'm pretty satisfied that my cases are better researched than most of the opponents. As far as the third key for anticipation, it sounds obvious, but apparently it's hard for attorneys, for a lot of them. I have to anticipate what's coming, either the questions from the judge, the arguments from the other side. I think the adage that attorneys prepare two cases is true, or at least I found that to be true. I prepare my own case, and I have to anticipate the other side's case. And truly, when I'm preparing a case, whether it's for motion practice or trial or petitions for judicial review, I'm preparing two cases. I'm preparing my case, of course, and anticipating the case that the other side will prepare. I've been doing this for a long time, and I still am. I guess I'm still shocked or disappointed or dismayed, but not surprised anymore when I have cases going and the two sides act like they're presenting completely, a different case, not really responding to the case or anticipating what's coming up. I guess attorneys are human, and maybe they're a little more human than other humans. Sometimes they stake out their case at the outset and will stick to that no matter what's coming. As I said, I try to anticipate what's coming, and and make sure to respond to what's coming.
Right.
I think too, to answer the first question a little more directly, I think this would be a welcome change from my private practice. I didn't actually count my client list when I came in today, but I'm responding to many different clients at the same time. I think one of the biggest changes, and quite frankly, a welcome change, would be I would have, as commission counsel, I would have one client to focus on. And I think it's time for me to take that step and to be in that position. I'm sure that the associate counsel has been feeling a large burden from not having counsel in place for a long time. I actually enjoy working with attorneys, even though I run a solo office. I do a lot of contract work. I excuse me, I give a lot of contract work to contract attorneys. I have a network of referrals with other attorneys. I very much enjoy working with good attorneys. I am and I have been a mentor for the Nevada State Bar since the TIP, Transition in Practice program, was implemented. I've been a mentor to some outstanding young attorneys. It has been tremendous to watch them and actually to learn from them. I've been a hearing officer for the board of the medical examiners. First thing we did there was we had a handbook of all of the NRS, NAC forms for, the standard intake forms, complaint forms, standard orders. I imagine something like that is in place with the Commission on Ethics. I've been a mediator for many years since the real estate division of the Office of the Ombudsman adopted the mediation program. I've been a mediator since that program was developed, although I resigned last year for various reasons. I gave a long letter to the Ombudsman suggesting some changes to the program that essentially would make the mediation more meaningful. But anyway, I've been a certified a mediator, referee, arbitrator, hearing officer. I've done a lot of different things, and I'd be looking forward to the change and focusing on the commission as my client. And as I said, the timing is pretty good. I probably would not have been able to make a transition in the years prior, just because of the long cases that I had, or whatever stage that they were at, nearing trial or on appeal or whatever.
All right. Thank you very much for those comments. Because this is a public meeting, the next several questions will relate to your job, okay? And it can be in your current private practice, or if you want, it can be about previous positions that you've held in practice. So how could you change things at your job or or did you make changes at your previous jobs?
It's a great question. One of the reasons, there were a couple of reasons why I left the partnership in 2011. One was because I think it's safe to say that everybody was feeling the effects of the Great Recession at that time. We never laid people off, but as our associate attorneys moved on, we did not replace them. So we wound up with the partners kind of each working, on their own matters, and a lot of overhead. I noticed so I joined a partnership that was already going, and I noticed that, we'd have a monthly meeting, let's say, or whatever the partners meeting was. We were always talking about improving our procedures. We were always talking about improving our computer and data systems. It was very difficult to make changes to a business that was operating already. I found that when I opened up my own office, although I had to do it on a very short time frame, and as nervous as I was about leaving a partnership and opening my own office, it was an opportunity to start over and implement the procedures from day one. And I think most of those procedures have held up, and I'm talking about the employee handbooks, forms, the computer systems. One change I need to make now, though, is I operate on a server system. Even though it's a small office, we operate on a server system with a contract with the IT provider. It's a pretty expensive contract. And I am at the point where the next big change is going to be moving to the cloud system if I stay here. And that would be a large change. As far as procedures, though, the case log is the first thing, and a calendar is a second important thing. Especially for an attorney, we have to have a calendar system. I have a calendar system and a duplicate. I imagine that a calendar system is in place with the commission, but again, that is one of the very first things that I would look for, because I know there are some deadlines when a complaint is submitted. Then when the complaint is referred to the review committee, there are some deadlines, and there has to be a calendaring system to keep track of that. I anticipate it's there. Whether I suggest changes to it, I wouldn't know until I saw it, but those kind of procedures are essential for the council's position.
So next question is, can you tell me about a failure that you've had in your career? And how did you handle it? And what did you learn from it?
I'm sure I could. I'm not going to be able to, I don't know that I can give you one specific one, but I have had times when something was not right. And I'm talking about on litigation cases, really, when something was not right. And in those situations, a few options have run through my mind: panic, or try to fix it really fast. And at one point, I found out the best thing to do is to call the client right away. Because I have some smart clients. And I think when we have had a real problem, I'm not remembering a specific one, but when we've had a real problem, I have some smart clients, and they are good about assessing, about offering some perspective on whether this is a big problem for them or not. And once we start talking, if it is a problem, we can usually find a solution. It sounds trite, but I believe it to be true that honesty is the best policy. I don't believe I've ever lost a client for that. In fact, I think that maybe I'm in a fortunate position that if we are in a difficult situation, I think I have the loyalty of my clients that they want me to call and come up with a plan as soon as possible. And I believe that that's the best policy.
Okay, thank you. Have you ever done something for someone and did not expect anything in return? And can you give us an example?
Yes. Well, I think the Big Brothers program is one. I think being a mentor is another one. Although you know, we do get something in return for that, and we get a lot of satisfaction. And oftentimes we learn something even from people that we thought we were supposed to be teaching from. I like to learn things. We learn. I learned things from my daughters. I learned things from the attorneys that I was a mentor to. I like to watch good attorneys in practice. So yeah, I have, well, I have other uh uh the activities I volunteer for. Yes. For those who live in Carson City, you might know the Night Off the Streets program. Starting at St. Teresa's Church and then rotating through some of the other churches in town. They provide a shelter during the winter months. I've been a volunteer for that. It's hard when I'm working though, and I haven't recently, but I've done that. So right, and all of those are activities that you don't get paid for, but you get rewarded for them.
So if I were to ask 3 of your good friends to tell me something about you, what would they say?
They would say that I'm a deep thinker, a big picture guy. Um, that I love athletics, done them all my life, and still do as much as I can. And those in the legal profession would tell you they've developed a word. My contract attorney friend has developed a word for my writing style. He calls it an athletic a writing style. And we've never quite sat down and discussed what he meant by that, but I think I know what he means. It's fast and it hits and does not spend more time than it needs to. I hope those that I have mentored through the TIP program would say that I was a good mentor also. I think they would.
Yeah, I'm glad that you elaborated on what he meant by your writing style was athletic, you know. It's
It's yes. You know, I always have to adapt for the situation though. A lot of the briefing that I see, it's on complex matters. And I found out that that the other side wants to complicate it to a point where it's hard for the judge to identify the issues. My job is to cut through that, and typically it's better to do that quickly. There are times though where long, detailed analysis is required. You know, on appellate briefs sometimes. It could be on some of the ethics issues here. It really depends on the circumstance. But by and large, what I see with my briefs is mine are shorter and more direct. And I can give you a related example. When I was working at the Brooks Shaw firm and we were hiring an associate attorney, I saw something, I think it occurred to me for the first time then. I saw a writing sample from a candidate, and it was good. And there was nothing wrong with the writing sample. And I liked the analysis, but I finished it thinking that it didn't deserve this many pages. And I keep that in mind. I think we're having, well, this is getting a little far afield. Our courts, almost without exception, are backlogged now. And we're almost to the point, the easier you can make it on the judge, the more they respond.
Very good. All right, next question. Would you characterize yourself as someone who gets ahead of deadlines or someone whose work is driven by deadlines?
The first, and preparation was one of my 3 keys. Since I'm solo practitioner, I do a lot of my own research and drafting, but I refer it out to contract attorneys also when I do have a little bit of a back and forth with them. The standard briefing deadline, let's say in Washoe County Court, is 14 days. So my contract attorneys will, when they're taking notes, they say, so we have until the 14th day. No, you don't. You've got 7 days to get it back to me, because whatever you give me is going to be revised. We're going to do additional research. We have to have time for the proofreading. We have to be way ahead of that. And also with preparation, if you're talking about cases going to court or petitions for judicial review, the deadlines are set. I mean, the deadlines to prepare the record, to prepare the briefs, they are set, and that all takes a lot of work. Overall, I think I told you that I do still spend time in the library. I would say that my method to preparing cases is methodical. One of the reasons why I like to see, I've already mentioned that I like to see the case log. One of the reasons why I mentioned that I keep a calendar and a duplicate calendar, I'm looking ahead. And we have to keep it going. And I would say that when I do have cases going, I'm working on them all at the same time. I don't mean that they're all in my, in front of me on the desk at the same time, but I'm working on the briefing, discovery, whatever it is. We're moving the case along the entire time. I don't like to pick up a file and just cram on it right before a deadline. No, I don't do that.
Right. Do you prefer working collaboratively or independently?
Collaboratively. That's one of the reasons. One of my main practice areas, homeowners associations, and usually people will grimace and say, Mike, you're kidding. And I say, no, because that's the best opportunity that I have to work with the board. I enjoy it. They come to me when they're having a problem. These are volunteers who are having a problem. They need help solving a problem. And it's rewarding to work in a collaborative effort to solve a problem. I still have other opportunities to do that in my office. I told you that I do refer work out to contract attorneys. I enjoy that a lot. I become friends with them. I think I would have more of an opportunity in this office. And actually, I think I kind of indicated that's one of the things I would look forward to in a change. I've done the litigation for a long time. I'm satisfied that I've done it well, but I'm ready for a change, and I look forward to it.
Thank you. Vice Chair Dufferin?
Thank you, Madam Chair. Thank you, Mr. Matuska, for applying for this position. I've got 6 quick questions for you, sir. So when you applied for this position, I'm assuming you saw it on the State Bar's website. Is that accurate?
I did, and then I went on the COE site.
And then did you get an opportunity to read the Ethics Commission's mission and guiding principles on our website and take a look at our statute 281A, NRS 281A?
I definitely have been through NRS 281A. I've been through 233B quickly. I've been through that in the past. Yes.
So based on your look at those things, in what ways do you believe you could assist the commission in ensuring its objectivity, independence, and impartiality, and make those things, make sure those are beyond reproach?
I would come to this position without any baggage. Never, I have not had any conflicts with public officials that would have created any kind of bias or problem for me or this commission. I'm a completely clean slate. I believe I mentioned that I make a point of trying to understand both sides of a case. I think that applies when the board or the review committee is reviewing and initial complaint. It's important not to have any biases or preconceived ideas, and I believe that I can accomplish that.
My next question is, do you have any experience in preparing or presenting meeting materials for approval at a public meeting? And if so, please describe those.
Yes, it's been a while, but I have sat in the council's chair for the Carson Waters Subconservancy District. At the Brookshaw firm, Scott Brook was attorney for Incline Village, General Improvement District. As I said, we've represented water districts also and other GIDs. More recently in my office, I've appeared before licensing boards a number of times. Contractors board would be the most often appearance. The cosmetology board, an ophthalmology board. So I've appeared before boards. I've appeared before county commissions on zoning and planning issues a number of times. That's coming at the public meetings from a little different position. I've sat as the vice chair for the Carson City Charter Review Committee. I sat on the committee for 2 terms and was the vice chair for the second term. So I've sat on the podium, I guess.
Sure. Thank you. Have you ever provided legal advice to any agency or private business on their litigation matters and or their daily operations? And if so, please tell us about that.
Not to a city or county. And again, it would have been a while, but with the water districts and subconservancy districts, we would have prepared legal opinions, definitely. I do it for my homeowners associations boards also, which operate under Chapter 116 of the Nevada Revised Statutes, but frankly, it has a lot of similarities to the open meeting laws.
Did you get a chance to look at any of our legal opinions? on our website?
I've gone back through the minutes. I did, yes. The advisory opinions?
Advisory opinions.
Yes,
That's what I meant.
yes, yes, yes.
And did you feel when you were reading through some of those that you felt comfortable?
Very,
Thank you.
very, and I've mentioned I can tell that there's been an emphasis on standardization and procedures. And again, I'm not sure if it started with this board or executive director or prior boards, but it's evident. And it's evident when I go through the records that are available that there's been an emphasis on that. And it sounds obvious maybe, but I think that not all of the licensing boards I've appeared before are standardized and organized to that point. So I do recognize that, and I appreciate it.
As we do.
Thank you. Mhm.
My next question is, what steps do you take before making a decision on how to solve a problem? And why do you take those steps?
When I was at the Brooks Shaw firm, the founding partners were Scott Brook and Bill Shaw. And Bill Shaw was a unique person, a unique personality, but he was a master communicator. And when I was started there and would sit in with him on his client interviews and client meetings, I was able to identify a style that he had that I admired a lot. He wouldn't just start giving advice to clients. He had a unique way of communicating with the clients and asking questions of them, such that the clients would almost come up with their own, that the clients would come up with the answers eventually. It was really unique. He had a really unique skill for, what would you say, for encouraging the conversation, asking the right questions, starting the process, getting the right information out on the table so that clients can make their own informed choices. And I don't know if they realize as much as I did watching this, that they were making their own decision, not just following legal advice, although it was so subtle, and in a way they were, but it was just so skilled and impressive. And that all, and they always were happy when they came up with their own solutions. At one point, we hired an attorney that had an LLM in tax. And he was going to be, we were going to have some large business matters coming up, and he was going to be our business advisor. And he was qualified and brilliant even, but he'd start out a meeting with a lot of advice. He'd go the other way, start out a meeting with a lot of advice, and the clients did not respond as well to that. And I really think, and whether it's an individual client or a board or a committee, I think the point I'm making is to facilitate the right exchanges. And that's how you come up with the right decision. It's not just one opinion, one legal opinion, or one opinion from a board member. It's a collaborative process, and people who are skilled at it can ask the right questions and get the right information out so that the best decisions are made.
My next question is, have you ever argued before a district court or Nevada Supreme Court on an appellate matter? I think you kind of touched on that earlier, but I wanted to hear more about that.
Well, I've handled many petitions for judicial review. I would have been probably on the complainant side on most of those, probably on water matters. I've done jury trials through the district courts, and I have 3 reported appellate opinions.
Can you tell us a little bit about those 3 opinions, just briefly? Got 2 minutes or less.
Yes, the first one was on a fraudulent transfer case.
Uh,
The second one was on an investment matter. And the third one was on a water matter, yes. And they all are reported and are precedent now. I've argued before the Ninth Circuit Court of Appeals, and that is probably the most intimidating body. And possibly you've heard that.
I can only imagine. I'm not an attorney, but I can only imagine. My next question is, based on your understanding of this position, what is more important? The ability to work as an independent contributor or as a team member?
I'm looking. I've done a lot of litigation cases, and that is an adversarial proceeding. I believe I've said that I've enjoyed working with my boards more than that, whether they are the HOA boards or the corporate boards. So I would expect if this commission, I would expect that the council position with the commission would be a collaborative working environment, definitely, and I would welcome that. If I can add a little bit to that too, I do have staff here. I've always had staff. I have contract attorneys, referral attorneys. I find that I believe that different people respond to different things. I like to understand the people that I'm working with a little bit, and quite frankly, talk to them the way that they want to be talked to. Some people might respond a little better to one style, some a little better to another style. I really try and understand what gets the best response from the people that I'm working with. If you allow me to add a little bit to that, one of the best continuing education courses I ever went to was a mediation course. And one of the first things the instructor did was to identify the different personality types of negotiators. You have aggressive ones, you have accommodating ones, you have meek ones, a few different types. I don't remember all of the labels. I probably don't have a label. I'm easy and accommodating until something starts to go wrong, and then I have to step up and say so. But I don't enforce a style at a settlement conference. I don't think I would enforce a certain style in an office environment. I like to fit in and see what people respond to.
So it sounds like you're trying to tell me you're adaptable.
Yes, sir.
Okay.
Yes.
Thank you for expounding on that answer. And those are my questions, Madam Chair.
Right? Commissioner Oscarson.
Thank you, Madam Chair. Mr. Matuska, thank you for being here and taking these questions. I have 6 questions as well. I think some of them you've already, if you feel like you've answered them, I think some of them they're not duplicative, but there's some overlap in some of the things. So if you feel like you've already answered one, feel free to say that. If I have any further questions, I'll ask you or one of the other members of the commission. So my first question is, what have you done in the past to prevent a situation from becoming too stressful for you or your colleagues to handle? And knowing the people you represent, I'm sure there's been a few of those.
Yes, I would answer that a couple of different ways. There's no escaping stress. um, um, I think um, well, there's no way of escaping it. And if someone is not stressed out or anxious before they start a trial, they don't have a pulse. I think the ways to avoid that from getting too stressful, number one, just be prepared. And I mentioned the preparation previously. When I'm starting trials or an argument, I try to be spontaneous, but I also have a full slate of notes and prepared questions and everything else just in case the the worst case scenario happens and I draw a blank. I've got cheat sheets on everything that's going to happen. I'm anticipating the objections about evidence. I try to be spontaneous on the responses, but I've got them all prepared and written out in case. I think the other way to minimize the stress is just through experience. I think that part of my practice has been I have a lot of cases where they're telling me, the client on the other side is so big, you can't beat them, or the other attorney is so smart, you can't beat them. I've never found that to be the case. I find that they have their strengths and their weaknesses just like anybody else. And the way to level the field, honestly, is just through preparation. And I've always been able to do that. In fact, if we were going to spend more time on this, and I was going to, and if I were to think of some specific examples, I probably would have a list of times that I was told, this guy's too smart, you'll never get him. Those are actually the people that will lose. You always have to be anticipating what's coming from the other side. You have to be able to do that. And if you lose your ability to do that, you're vulnerable to a loss. And as long as you can anticipate that and prepare for what's coming, there really is nothing to be too nervous about. And if you really are nervous, you make as many notes as possible so you have a backup.
Thank you for expounding on that. Have you ever held a position where you could not ask for guidance from other persons in your workplace? And how did you handle that challenge?
A couple of times. Possibly not so direct. I did have one attorney that I was working for. I can't even remember what the project was, but I wanted it to go one way. He wanted it to go another way. Finally just said, just do it and stop asking questions. I wasn't quite satisfied with that response. I had a situation where an attorney friend of mine, let's see how to say this. An attorney friend, this is a little different circumstance, but a difficult circumstance. I had a situation where an attorney friend of mine was in trouble with the state bar and had to have a mentor to work on a mentor plan and asked me to be the mentor. And of course I said yes. And I wound up, I took over one case that he had going that was in very bad shape. And I went to court and got reamed out because of everything that he had done. And I was really conflicted and struggling with the question of whether I should tell the judge, you know, I'm his mentor too, and there are some issues here that would mitigate some of the things that the judge was saying, but I wasn't at liberty to disclose them. And I was a little disappointed with that exchange. There's such an emphasis. Well, attorneys have a stressful position. There's such an emphasis on giving attorneys an open door policy for addiction counseling without repercussion. This was a little different, but kind of in that vein. And I thought it was unsatisfactory for the judge to be saying those things about the attorney I was mentoring without knowing what the situation was and without being able to tell them what the situation was. I'm in a solo office, so I don't have a lot of people to ask guidance from here. I do have a couple of attorneys. You know, I'd say I've called 3 outside attorneys in the past couple years when I really am stuck on a question. But this is a solo office. It's a pretty small office.
I think your examples were exactly what I was looking for, so thank you. What if I, as a commissioner, had a question? How would you handle responding to an individual question from a commissioner? And do you think that legal counsel should provide the other commissioners with the same information? I'm happy to read that again if you'd like.
Go ahead.
What if I, as a commissioner, had a question? How would you handle responding to an individual question from a commissioner? And do you think that legal counsel should provide other commissioners with the same information? I read it all as, it's actually three components to what I think a question that could be wrapped right into what your answer would be, I believe, perhaps.
Well, I'm at a little bit of a disadvantage because I believe the detailed answer would require some of the very fine points of the application of Chapter 281A, and I'm not there yet. If it were a simple question like, what's the status, or are the reports ready? I think counsel can answer that. If you're asking if you have a potential ethics issue in your position, and you're asking that of the counsel, is that the question that you're asking? If you had,
It could very well be whether I have a conflict or not.
Let me just kind of clarify. It could be, do I have a conflict on this issue because I happen to be friends with this person, this case we're deciding, or this advisory opinion?
I'm going to expect that would have to be something a little more than just a chat over the water cooler. If there's a concern about conflicts, I think there's got to be a procedure for that, and you would want a real answer. And probably that answer is on the record somewhere. I can give you an analogy to what a corporate counsel is being taught these days, and it's very complex. Especially on whistleblower cases or some kind of potential securities fraud issue. Corporate counsel's duty is to the corporate board. If there's a problem with one corporate board member or officer, sometimes that attorney has to refer the matter to review by outside counsel. So this is, this council position is the council for the board. It's not council for one specific board member. Of course, there is the overlap, of course, that council would safeguard against some appearance of conflicts of interest if it were obvious. But council is,
I think you're spot on. I think that's exactly the answer.
and then I get to study it more.
Oh, and that's good too. That's a good answer too. You don't know, there's some parameters and things you would work within, and I think that's great. I think that's a good answer. Let's see. How would you, and this kind of wraps into that too, I guess, a little bit. How would you handle two commissioners disagreeing on a position the commission should take on a matter? That
I'm
can't be
not,
rodeo for that either, I don't think, huh?
pardon?
Two board members disagreeing on something, I can't believe that would be your first rodeo.
I get dissenting opinions from the appellate court all the time. I'm not sure that I don't see that that the board has to be unanimous on every decision.
Yep. Thank you.
If I can add a little bit, this is just a little point of interest. Our current state Supreme Court really tries to be unanimous, and there are some attorneys who think that we're losing a little bit of the ability to develop, of our case law through dissenting opinions. I don't think that any appellate court has to be unanimous. It's nice in some respects, but it's not required. And as strange as it sounds, there's a place for a healthy dissent even.
Thank you. We had a case like that just today where, I happen to be the dissenting member of what everybody else thought was good. And that's okay. I think that that's okay. We all come from different backgrounds and different thought processes. So I think that's okay.
And when I've appeared before county commissions on master planning or planning or zoning issues, it's often that they're not unanimous.
Those can be quite contentious. I have witnessed some of those.
Yes.
Right, so especially zoning issues. What is your protocol, sir, for customer service, including returning phone calls and emails?
The same day. I do have another procedure in place though. We do get a number of first-time calls, so it might be a little different in my office, or maybe not. I'd have to think about that a little bit. But most of my cases, some of my cases are large cases that might be of interest to, I don't know, to people outside of the parties to the case. But most of my stuff is not interesting to anybody except for the parties and the attorneys in the case. But I have been part of cases, and I have seen cases where sophisticated parties will start calling all the prominent attorneys in the area. And maybe you know where I'm going, and discussing the case with them a little bit, and then hiring a different law firm so they can disqualify all of the attorneys that they've spoken with. So we have an intake process for cold calls. For new callers, I don't speak with them. We have an intake process. We have to clear the intake process and that initial conflict procedure before I speak with the new caller. I don't know what the protocols are for the staff here to take a call on on a new complaint. I imagine that there are some protocols in place. I'm not sure that they would speak directly with the council first.
I think, Ross, we talked about this one with somebody else and what you want to, do you mind sharing your?
Yeah, I mean, I think it's interesting because the one part of that customer service to think about is with the commissioners, but one of the functions of the commission council is the advisory opinion process. And so you have a lot of public officers and employees out there who ask for help, and our process, we've got a 45-day window to get the opinion done. And sometimes that can be a big period of silence for folks and they want to check in. So that's one of, I think, the big things when I think about the most customer service that commission council position does is one to the clients, the commissioners, and then two to those folks waiting for advisory opinions.
Yes, yes. And in the case of my private practice and my small office, I've got a duty to make sure that they're not going to conflict me out with any existing clients. Whenever someone calls about a complaint with the neighbor or a complaint of a homeowners association, I cannot talk to them until I know, until I get the names of who they are involved with. And I've been lucky that my current legal assistant is a terrific communicator and great with the intake process, and that's key.
Yeah, I know this might be tough for you, but this is your last question. You can breathe now, it's okay. So this one is interesting. We talked about this a little bit. The position of commission counsel is a salaried position versus an hourly job. Do you understand that the legislative session is 120 days of dedicated time? From your other clients, I'm sure you understand that, often including weekends. Will you commit the time needed to assist the commission throughout the legislative session? And let me just give you a brief synopsis. We've got a bill right now that's in the legislature that we're working on. And Ross is basically going to pitch a tent in the front yard of the legislative building and be there 24 hours a day in case something goes, as you know it does, to different places. He's basically going to have to be there all the time. And council's an important component of that in many instances because decisions are made on the fly at the legislature, as you well know. So are you willing to commit that time, and do you understand that commitment?
Yes, and yes. And actually I would look forward to that. I actually provided a comment letter to the Commerce and Labor Committee, the Senate Commerce and Labor Committee, on some of the a tenant law changes. And possibly you're referring to SB 431. And when I was looking through the past minutes, I did see the comment letter from the executive director on that. Those would be large structural changes at the state level, and I understand the reasons for the comment letter.
There you go, Russ. Madam Chair, those are all my questions. Thank you for your responses, sir.
Right, thank you very much. We'll get down to the end of it. Mr. Martuska, if you are appointed as commission counsel, you'll be required to file a financial declaration with the Nevada Secretary of State that discloses certain details of your private financial information. Do you have any concerns with this filing?
No, I don't.
Okay. Have you read the restrictions on the position of commission counsel listed in NRS 281A.250?
I have.
You have or haven't?
I have, yes, I have.
There are three main restrictions, and I want to confirm that you will abide by the following if you are hired for the position. Commission counsel is precluded from being actively involved in the work on any political party or political campaign. Will you comply with this restriction?
Yes.
Commission council must devote their entire time and attention to the business of the commission and not pursue any other business or occupation or hold any other office detracting from the performance of these duties. Do you comply with this restriction?
Yes,
Except on behalf of the commission, commission council may not communicate directly or indirectly with the state legislator or member of a legislative body on behalf of any person to influence action on certain legislative or policy matters. Do you comply with this restriction?
yes.
Do you have any questions for us?
I had two general questions. I think I can anticipate the answer to the first one. What are the big changes, or are there any major changes that that this commission sees in the near future? And it might be SB 431.
Well, yes, I'll address that and my fellow commissioners can chime in and the executive director if they want. Yeah, if SB 431 came into play, that would be a major change and kind of change the purpose of the commission. Other big changes, I mean, I wouldn't call them big changes. If AB 66 gets passed, there's some big changes in there. The legislature is carving themselves out of the purview of the commission with their amendment. We also have some changes to some of our processes in there, adding some better protections for the person who filed the complaint and adding some better due process for those people who have a complaint filed against them. And we've also added in there abuse of your public office without having a pecuniary interest. So those would be some, what I would call bigger changes and stuff. Ross, you want to add anything else to that?
Yeah, I think the biggest change would be is if AB 66 passes, we'll have a new ethics violation, right? And that can be a challenge, especially in the commission council role, because there's no precedent to look at how the commission's handled it before. So that will be a big challenge, and just making sure that we're able to adapt our procedures and the processes we have to stay organized in some of the new notice and confidentiality requirements under that new law. I think those are our biggest ones. I think in addition, we have seen a upward trend in the overall caseload. And so trying to think about, are there some practices that we can streamline so that we can handle a larger caseload with the same number of people?
Very good.
And just for the record, we blame Ross for that in his outreach with social media and all those kind of things. So it's his fault. Give him the numbers that we were just talking about. Last year, we had how many advisory opinions the whole year?
Last year we had 54 advisory opinion requests for the year.
So far to date, we have.
We're 21, 22. We just got another one yesterday, so that's about 22, I think.
And how many people have you done outreach to this year already for ethics training?
A little over 1,300.
And that just makes people more aware. So
That's a lot.
It is a lot, and it's a big job, and he does a great job of it. I think from my, oh, I'm sorry, I didn't even ask permission to speak. I should have. Madam Chair, may I speak?
What's new?
Oh, gosh, it's rough here. It's tough.
Go ahead, Commissioner Oscarson.
I thank you, Madam Chair. I appreciate the time. I think the changes at the governor's office level for me are going to be very difficult if that happens. I think keeping us a separate entity away from any kind of oversight like that would be critical to this process maintaining its integrity. You know, I don't know what your thoughts are, but I'll tell you from a commissioner's perspective and from a former legislator's perspective, there needs to be an independent body that protects what goes on without interference, so to speak. So that to me is a big issue.
So you would have ostensibly under 431, there would be a secretary who is subject to chapter 281A that would have oversight over the commission, that was enforcing chapter 281A. That's not easy.
Well, and a couple layers after that.
Yeah, and then there are layers after that, and then what does the commission do if it gets complaints about the individuals that it supposedly reports to and all those kind of things?
It doesn't work. It's different. No, I just, yeah, I see the basis for the executive director's letter.
Madam Chair, I relinquish my spot to you.
Thank you. And you said you had 2 questions? Or-
Well, the other one was already answered. I was going to ask about a backlog and an anticipated a caseload.
Oh,
And we just answered that. And so I mean, we could ask the question jokingly a little bit, who's going to be happier to get counsel appointed, the commission or the associate counsel?
staff, all of staff.
Yes, yes,
Staff is what matters.
yes.
And our Deputy Attorney General will be happy too.
She'll go back to her
She'll get
own-
to
Right.
back
the
to her
whole
own
job instead of doing our job, her job and our job.
She
Very
just-
good.
Yeah, but she'll miss us.
I will. I honestly will. Say that.
So if you don't have any further questions, then is there anything else that you would briefly like to add that will assist us in evaluating your application?
Not at this time, no.
Do you have a sample of a document on which you were the principal drafter?
Yes,
All right, if so, please provide it to our Deputy Attorney General, St. Jules.
okay,
She'll get you, you can get her your
Yeah,
information. Okay,
We'll make
good.
the connection.
And this then will be provided to the commission if you're selected for another interview.
okay,
Next steps, we will be making a decision today on who we will interview in front of the full commission. And if you're selected to go before the full commission, besides answering questions from all of the commissioners, you'll be asked to make a presentation on an advisory opinion and a jurisdictional recommendation. And if you are selected to go before the full commission, our Executive Director Armstrong will be sending you out
All
the
the
questions, all the
information,
information to do
Okay.
the advisory opinion and the jurisdictional determination. So I just want to say thank you so much for your time today and coming to see us. And thank you very much for your interest in the position. We appreciate it.
you're welcome and thank you.
All right, thank you very much.
Thank you.
Thank you.
All right, let's take just a brief little break. I need a little pit stop. All right. Now this is item 3D, referral of candidates to the commission, the full commission for commission council position consideration. I'm going to ask my fellow commissioners for their comments. Bear in mind, we don't have to refer any to the full commission if you don't think that they have potential. We can refer 1, we can refer 2, and we can refer none. So I will start with Vice Chair Dufferin with his comments.
Thank you, Madam Chair. So just my overall thoughts on the 2 candidates. I liked both candidates' personalities. I think the personalities would fit well with our organization. Personality is just one factor in my mind. Looking at the entire picture of each candidate, I felt that Mr. Matuska just had a little bit more of a profile. If you look back at some of his answers and his background, kind of in my mind fit better the position that we're trying to fill. I liked his answers about being prepared. Looked at our opinions on our website, felt comfortable with those. It's not to say that Mr. Peralta, didn't give me good answers too on that regard. I just felt his background didn't fit as well as Mr. Mateska's background. I definitely want to hear from the two of you also. I can go into some more greater detail, but I just felt my overall impression was that Mr. Mateska would probably be successful in this position. Both of the gentlemen would have to transition from being sole practitioners into basically doing an administrative law, which is what this government administrative law. So there'll be some transitions on their part, but I felt like Mr. Mateska would actually have an easier time transitioning into this type of work, is based on his background and dealing with other boards and commissions and other, you mentioned HOAs and you mentioned IVGID and some other organizations that he's been involved in, and his time as a hearing officer, I thought stood out to me, and I thought that would be helpful too. Not that this is a hearing officer position, but we do have meetings when we try to do settlement conferences, and the commission council is part, usually we'll take a commissioner and the commission council will try to arbitrate some of these things and try to come to settlements. So I thought that hearing officer position just kind of rung out to me that would be a helpful trait. That he also the mediator and just his overall general background. It's been a long day, so I'm kind of rambling and I apologize, but so that's kind of where I felt. And as far as moving either one or none forward or both, I would actually think I would prefer to remove Mr. Mateska forward for the full commission. I think he would probably fit, like I said, better and would have the best chance for success in this position. Those are my comments, Madam Chair. Very, very bad comments. It's been a long day, but thank you for that opportunity.
Thank you. Commissioner Oscarson.
Madam Chair, I disagree with Vice Chair Duffer, and I think his comments were succinct and were exactly what I was thinking as well. I liked both candidates. I liked the personalities, and I liked what I really found most interesting is I think both of them were very sincere and very honest with their responses. Both candidates have you have an understanding of what we do and how we do it. But I think for the purposes of what this commission does, the more seasoned person with the most experience and having dealt with some of the things we have dealt with and we continue to deal with, in addition to the additional workload that's going to obviously affect us, and how, if some of these changes, we hope they don't, some of these changes take place, how we would work together with them to do that, I think makes Mr. Mateska the candidate that we should move forward.
Okay, thank you to my commissioners. I liked both of them, all right? And I like Mr. Mateska because he has a lot of experience, okay? But there were some things where when he was asked about, did he look at our mission? He only talked about 281A and the laws. He never talked about our mission. And his response was, he doesn't have any baggage or preconceived ideas, and that's how he would carry out, doing the job. Mr. Perlata, he said that, he would, become mastery of the law, be judicious in carrying out our mission. So to me, I thought that was a better answer there. It was interesting asking about the friends. Perlata, he said honest, sincere, trustful, kindness and stuff. And I think sometimes you have to have a personal side in this. You can't just be all by the book. The other one was deep thinker, big picture. loves athletics. Writing style, I did like that he said his writing style is short and brief and, which is a good thing. I like that, They both pretty much had the same thing about deadlines. When asked about doing something for someone when it wasn't, you weren't gonna get anything out of it or something. Mr. Perlotta, he talked about being pro bono and helping his clients and, ones that it wasn't a fit in his practice, but he wants to help. And I think in public service, you have to want to help, right? Mr. Mataska, his answer was pretty much about his charity work that he does, which I commend. We all do that. So I had that. In the problem area, there's another answer that wasn't answered. When we talked about problems, he talks, Mr. Prada said, you need to understand what it is, the concerns, really understand both sides of the law. But Tosca, he kind of elaborated on that on another question that, when you prepare for a case, you can prepare 2 cases. Then when we talked, I also liked one of the comments that Prahlad said is that he would talk to the previous commission counsel. And I think that's important, okay? I think he answered the question better about when you asked, if I had a question, how would you address it? And Prahlad said, well, first I would need to know what my boundaries are, what the law is. Mataska, he's kind of struggled with that, even when we told him that, he thought we were coming to him, asking him, oh, I have an ethics problem. When I said, well, it's on a case and, we might have a conflict of interest, he really kind of struggled and didn't say, well, I would need to address the law. I mean, I had a difficult time with that. When asked the question, what do you do? Have you ever had a situation where you can't ask somebody for help? Prahlada, he kind of said, well, I talked to other people, and then he got back to the question and said, well, I just have to get down and do it, and basically does his research. Mataska didn't really answer it, I didn't feel. Again, like I said, I like his experience, but a concern I have when we're talking about, should you be a team member or work independently as commission counsel, his response says, well, I think you need to understand people. You be a team member, understand people. And he talked about the mediation course. And he says, I don't have a label, I'm just blank. And I'm sorry, every one of us has something, okay? Procedures,
can I-
yes,
can
you
I-
may. Mhm.
So yeah, on that answer, I think what he was trying to tell, what I read in the answer was it's not the my way or the highway, it's more of like, I adapt to the people that I work with, and I try to like figure out how to communicate with them, try to figure out how to motivate. I'm just not like, I kind of like that style because that's my style. I like to get to know my staff and the people I work with, coworkers, and try to figure out how to motivate them. And I think that's what I read into that answer was that's what he was trying to say. So he's kind of, it's not that he doesn't have a personality or a management style. I think what he was trying to say is that he adapts to whomever he's trying to motivate, because everybody is motivated by different means. And so I didn't think that he was just didn't have a personality. I just thought.
Well, no,
didn't
I'm
have a
not saying that.
style.
It's like saying that, I don't have any of these bad traits or whatever, or any traits of whatever. If I were to have to make a decision today on who I would pick, I would need to see more. I would rather see their analytical skills, their presentation skills, to see if they can do it. I would prefer to move both of them forward at this point in time. That's my shape. And I would like to ask our executive director his observations,
Yeah, I think,
because you will be working with him.
yeah, one of the things the interviews can be helpful for is to go, oh no, right? And I didn't get that with either of these, neither of the, I've enjoyed listening to both of them. Neither of them gave me red flags in terms of any of their legal answers or their approaches. I thought those were well done. I think the observations you've made about the additional experience of one candidate over the other is accurate. So much of, and there was nothing in terms of like personalities and working with the team that I was concerned about. You know, both have those solid personalities that would fit well with the team. I would say so much of that commission council's job is the writing, and so it's hard for me to say which one without seeing their writing, because that's, at the end of the day, it's crafting those advisory opinions and any of the, what, so I call it like the bench briefs that you get to help you with a decision. You know, I think there would definitely be a learning curve for both of the applicants in different ways. But that's exciting to help bring someone new on board and get them up, you know, up to speed and let them bring their contribution to the team. So those are just my observations. That I liked it both. For me, you know, I would want to see their writing next.
That's my feeling. I just, because I don't, today I think we kind of saw, you know, do they, personality wise, do they have a glaring issue? Okay. And neither one of them did. Okay. And I think either one could work with the team. But we don't know if they can really write, and that is such a critical piece of this job. And I think we need to do it, have them do the presentation, have them to do the advisory opinion, the jurisdictional determination, and a sample of their writing. I think that's really important. That's why I would like to submit both of them to the full commission at this time.
Yeah, just further comments in my mind, just once again, back to Mr. Peralta. Just once again, good to me, it goes to experience and the type of lawyering that he was doing. I didn't really see a fit in that regard with this job. Doesn't mean he can't do the job. And I hear the chair and I hear the executive director loud and clear. Maybe we need to give this gentleman an opportunity to look at what his writing style is. I don't know if that's gonna sway the full
Well,
commission, but
well, I mean,
I'm open to.
a big part of the commission council's job, a big part is the advisory opinions, okay? And I think when you ask each one of them to go and present and do that, that's going to be very telling to see if they get it. Because doing the advisory opinion, you've got to start learning the law, all right? And, you know, you could be in practice for a long time, this is a totally different part of the law, and you figure, oh, it's real simple, I can just do it. And the other person who hasn't been in as long may take more effort and do more research and learn more about the law and do a better job. That's my feeling.
Okay, so let me put a wrinkle in the whole thing. Are either one of them the right fit?
You know what?
Because I don't want to get to a place where we're desperate to hire somebody.
Well,
And even if they present it, even if they write it and present it, you're not watching them write it. You don't know who's writing it or what they're doing. I mean, there's just, I mean, I agree with you that that's an important part of the job. But I also wonder, in going back on what I said, I'm not sure either one of them are the right guy. I'm not sure one personality would fit. I think one is a much more direct personality, but has more experience. The other one doesn't have the experience, but probably has more of the personality. and I'm not sure that, you know, in thinking back on it and listening to your comments, I don't know that either one of them would move forward, should move forward.
Well, it doesn't, okay, we haven't had anyone. It'd be interesting to see what results we get with the writings and things like that. And it's not just the writings, we'll have them present, you know, why, you know, you're gonna go and do a presentation about your advisory opinion and why you came up with this.
I think we can set our standards high. And I realize we haven't gotten anybody, and I realize it's a challenging market and all those things that we've talked about for months now, since Tracy left. And I'm just, you know, I don't want us to think that we just need to settle for something. And ours is the first line of defense, right? Ours is the first line to determine whether somebody's appropriate or not. You send it to the rest of the commission, and you know, they're basically going to go on the referral of what we've done and how we've done it. I mean, they're all independent thinkers, but by the same token, they know that we need to get some help here. And I know Lana can't be here forever. I also am hoping that, I was hoping we'd have a few more that, well, okay, either one of them is gonna be okay, but not great. Not great right
Yeah,
now.
and I wouldn't say that either one of them wouldn't be great, because I've had many jobs in my career, and a lot of people looked at like, why did Dufferin get that job? Then I actually got the job. Probably shouldn't have gotten the job, but excelled in it because I wanted the job, and I took the time, studied it, talked to the predecessor that was in the position. I mean, you can be as successful as you want to be, and we can make that person, you know, not the commissioners, but you know, if the person wants to be successful in that position, I think they can. The fact that these two individuals got to us to this point, that means they're qualified for the job. Now, so I don't feel like either one is not qualified, and I don't feel like they're like we're settling. I didn't want to say that. I didn't want that impression to come out. I'm just saying, I felt like out of the two individuals that we just looked at today, you know, the big picture in my mind is Mr. Matuska out of the gate, based on the information we have just in this small analysis, would be more successful in the long run in the position, but I could be completely wrong. And I hear both the commissioners, and I hear the chair, and I hear the executive director who wants maybe more information. More information being like, let's take a look at their work product. Let's see how they do a presentation. We didn't get that today.
Yeah.
So in all fairness to the two applicants and to us, we didn't get that either. So that may change our mind as
And
well.
to me, that's a little different than when we were hiring for the executive director position. We kind of tell it was based on, you know, his experience, but his personality, okay, and the fit. And this one is, it's more of the legal skills that they need, because this individual will work independently pretty much most of the time, okay? I feel that, well, you know, the one concern, and maybe it's not a concern, I can understand why Mr. Prada wants to get out of private practice because he was spending too much time doing the business part of it, okay? And if he had employees, I totally get it. That's why I don't need more. And so, but I can see him wanting to, you know, do that. The other one, he's been in private practice, working super hard, and wants to get out and take it easy.
But it's not an easy job.
I know, but some people perceive it as being
No,
easy.
but exactly, to your point,
Yeah.
it's not an easy job. And my comment to him was, it's only gonna get busier.
Mhm.
And I don't want there to be any misconception about I don't want there to be, and settling wasn't the right word, Mr. Dufferin. I meant that with respect, not with disrespect. I think that I will support whatever you both decide. I won't go against what you decide. But by the same token, I think that I think we're just grabbing the first two candidates because that's all we've gotten. And I feel like that's a little bit disingenuous.
Fair enough.
So let me ask this of our council, I guess. Could we go and say, we want to continue interviewing? We may consider you for the full commission after we interview a few more people. Because it's not like these guys are jumping to other jobs, I don't feel.
I do think you can table it for a later
Yeah,
date.
it's possible.
Yeah, I think you can
So
table
we
it.
can table it and say, okay, we will not refer anyone to, we're gonna table it,
We're gonna take no action at this time.
take no action, okay? How's that sound?
I mean, you guys gotta be comfortable with it. I just, listen, here's the only thing I have to go on. I've interviewed a lot of people and done a lot of, not nearly like you guys have. Brian, you especially have interviewed a ton of people and know what's going on. Ross, I know you have too in your position. And tell me if I'm wrong, because I'm happy to have you tell me that and I'll get upset and throw things around and leave the room. No, not really. Lane is looking at me going, Will? I just think I think it's only fair to have, I mean, you got a 50-50 shot here. And I'd rather have I just don't, something with me, when we interviewed for our executive director, and granted, it's a different thing. But without any deliberation, without any talk, without anything, we got down to two candidates right away, without even batting an eye.
Mhm.
And we knew both of them would do a good job. One just won out of the other for a variety of reasons. And we're glad he's here today. The other candidate was great too. I don't
Yeah.
feel like either one of these are great candidates.
Then
And I'm
let's-
sorry, Madam
well,
Chair,
then-
I please don't.
Well, then I think we should table it to see if we can find some better ones. Okay, some that are better. And, at some point, we're gonna have to go to the next step so we can see what they can really do.
I get it. Can we have them do that without, I mean, couldn't they submit that back to you?
So we were whispering about that.
So that's a-
We don't think, based on the way that this
Was set up.
agenda item is written, that you could, but you could table it and then have another personnel subcommittee.
Mhm.
You could, depending on the number of candidates that come in, you could say, okay, we've got these 3 new candidates that we want to interview and have them do those assignments. And then these 2 do their assignments and consider all 5 at a future meeting to send
send
some
forward,
to the
okay.
commission.
And I think that's very valuable. I think to have all that information first would be, and then if it looks good, again, and I don't want to insinuate anybody's gonna do anything, but most of them probably have staffs and things that do, I mean, they have a few people at least that could help them do that. So I think it's important to see the quality of that product. And then I think it's important, obviously, to see the presentation of that product. But I don't think that we have, I just don't think we have what we're looking for quite yet. Maybe we do, but I think there's some trepidation on my part.
Yeah.
And I hear loud and clear, so I think I'm ready to make a motion that we table this item and that we table it so we can get further information from the 2 applicants with vis-a-vis the,
Well, don't we have to interview some more and then we can get
Well,
further?
Yeah, I don't know that we can get further information just for the personnel
Mhm.
subcommittee.
Right.
I think you can table the decision on whether to refer at this point,
Mhm.
but if you're gonna ask further information, I think that would be contingent on a referral.
Yes.
So so what's the purposes of tabling this?
We'll say,
So if we table it, what does that mean?
That means that
we're not gonna get further information. We can't make a
well, no,
decision.
that means that then say we interview another 3 people, okay? For
So you're
solo.
just saying, we're just putting these two on hold,
Right.
basically is what you're saying.
Yeah, instead of
I
just
understand.
throwing them out.
Neither one of them appeared to be, having to do, this is a good time for me. Both of them said, this is a good time for me. Would that mean a month? Would that mean,
Yeah, I mean,
We
I'm
didn't
not
ask either one of them, nor should we have, I guess, when you could start.
at
right?
this point,
We didn't ask either one of them. I don't get
Well,
the
it's
idea
not-
that either one of them
I don't
are.
wanna also, I don't wanna put people on hold, so to speak, so
Right.
that they're waiting for us to get our business together, but really what it is to make sure that once again, that we get the right person for this
Mhm.
particular job.
Well, and
And that's
correct me if
why-
I'm wrong, I heard you talking about it, but as soon as it went on this bar website, you had ding, 2 right away, right?
We had 3.
3, yeah.
But it is still up there.
It's up for 30 days.
Have you gotten?
I think, right?
any
30 years,
further?
30 years,
And how long
No.
has it been on this particular website?
2 weeks.
2 weeks?
I think we're about halfway through.
So we just might.
So do we need to table it for X date, or we just table it?
No, if it's on the table, then it's on the table
Yeah,
and it just sits there
so you just
until,
make a motion to
As
table.
long as
it.
the
it's,
chief clerk's
as
desk,
long as it, so potentially it can be an infinite table is what you're telling me?
yes.
Mhm.
Okay. I don't know if that's fair to the candidates, but.
Well,
think
I
it's
mean, we
Fair to
can
the process.
Well,
Because the
we could
process-
say,
just,
couldn't we say, let this ad run, in fairness, right? And I hear what you're saying. In fairness, say not tell them we're gonna let the ad run out, but we're gonna push this and work through some processes however you want to word it. That's not the way to word it, but and by May 15th, we're going to decide who to move forward or not, or whatever.
mhm.
I mean, can you do something like that?
Well, I
And give
think-
them a date certain.
Well, I think we really should do, since we can't give them a date certain, because we don't
know.
We don't know. I think we should just
Just tell them,
table it, and then with the understanding that we'll move forward as quickly as possible.
and, let them know that the subcommittee just felt that we wanted to interview some more people. Not that they were.
Now, I've seen that happen. I know people who've gotten letters that said we want to interview some additional candidates. And then one of those originally interviewed ended up with a job.
Yeah.
So they went back and said, yeah, these were good candidates. These were really good candidates.
So,
So
that's,
are
yeah.
you okay
so-
with that? I
So you
mean,
don't-
Yeah, I
Russ,
mean, I think
does it make, can I, Madam Chair? May I ask
Yes.
the executive director what he thinks?
I think that makes sense. And I think to your point, one of the issues with only having 2 people to interview, right, is it maybe they both would have risen up to the top in a group as 7 or whatever, but we've just gotten the 2. And so I think letting the ad run and seeing what else we get, and then making the decision.
Right, so it's, the understanding is we may not get anybody else, and we still, so I guess.
If we
so
don't,
if we
then I
don't-
would be
if we
willing
don't-
to.
So when you table something, that means the 3 of us are gonna have to meet as the subcommittee once again,
Mhm.
if we decide to move this forward.
Right,
Or one way or the other, or we say we're not moving them forward.
Right, and that could be, it could be a quick, simple agenda.
Yeah,
Zoom.
gotcha. Could be a Zoom call.
Definitely.
Yeah.
Understood. So my understanding is that we don't need a motion for that. The chair just tables the item. From an open meeting law standpoint.
I think Tracy would make us make a motion.
I would do it in
Yeah.
abundance of caution.
Make
Before
a
you
motion.
do that, do you want to weigh in? Do you have any thoughts?
I don't think I'm qualified to weigh in on
Because she could be a potential applicant.
There you go.
Okay,
You can walk to work.
Madam Chair, based on this deliberation and back and forth with the 3 commissioners and input from staff, I would move that we table the item and not make a decision right now about moving these 2, moving or not moving these 2 applicants forward to the commission.
Is there a second?
Yeah, I second that. And again, I just want to make sure for the record, it doesn't reflect that there's any disparaging anything towards either one of them. That it's
No.
just a question of.
I just feel like I'd like to interview a few more. I just hate picking just the first two that come in, and they were both very qualified. And they had their own areas of qualification.
Their own strengths,
Mhm,
and some of them had their own weaknesses.
mhm.
As we all
Okay.
do.
And if
So-
they choose, and I have seconded, but if they, I'm just
Yeah.
discussion, I guess.
No, all right,
No discussion?
you can discuss.
And if one of them chooses not, or both of them choose not to move forward, or say, I can't wait, or whatever it is, then so be it.
Yeah. Mhm.
I'm done.
All right, all those in favor, say aye.
Did you second that?
He did.
I did second.
Thank you for seconding that, and aye.
Aye.
I said aye,
Okay,
twice.
post,
So I voted
Right.
twice now.
motion carries. All right, now, public comment. Executive Director Armstrong, are there any members of the public present, or have we received any emails since we've been meeting?
There are no members of the public present. We have received no written comment during this time, and there is nobody on our Zoom.
All right. At this point, I'll entertain a motion to adjourn.
I'll make that motion.
I'll second that motion.
All right, all in favor, say aye.
Aye.
Aye. We're adjourned. Whew.